Hi everybody, good afternoon. This is our fifth session this afternoon. Gosh, had to catch up there. It's been a busy day. We've got 6 webinars throughout the day talking about various aspects of risk. So this morning we've covered ESG, we've covered general global risks, we've covered a little bit on cyber, and we've done some work as well talking about ISO standards. Now for the remainder of the afternoon, we're going to be talking about a topic that myself and Anna are quite passionate about, geeky about, not too sure what the right word is, which is around data privacy and the GDPR, and in this instance a little bit of other legislation called the PECA, so that's the Privacy Electronic Communications Regulation. That's quite hard to say on a Thursday afternoon at 3 o'clock when we've already done quite a few of these. Thank you to those of you that have been with us throughout the sessions today, and welcome to those that are listening on playback. Just a few items of housekeeping for you. This session is being recorded, and that's obviously been recorded so that we can offer it for playback at a later date. There is in your GoToWebinar control panel, there is a question and answers box. If you'd like to ask myself or Anna any questions as we go through the session, please do so. And we've also got a chat box. So if you've got any problems perhaps with technology, then Maneva and Debbie are standing by to try and help you with any of those technical challenges that we all have from time to time. What else have I got? I can say as well that save the date. For the 9th of December, we will be delivering our final set of webinars on the 9th, and I'm pretty sure that because of some of the changes that we're expecting to see in the legislation around the GDPR and the PECA regulations, that we'll be doing a GDPR update then as well. So Anna, did you just want to introduce yourself and we'll then start the session?
I can do. Hi everybody, I hope you're all well. Unlike Helen though, Helen's been doing these all day. This is my first one today, so if I'm a bit rusty, my apologies. So my name's Anna, I'm one of the senior data protection consultants here at Risk Evolves, and as Helen said, yes, I'm probably a little geeky when it comes to this stuff. So Helen and I will try not to get too geeky, eh Helen?
Yeah, we'll try. This is probably one of the more technical sessions that we've got going on today, and certainly it's probably for some of the individuals that are more familiar with the GDPR and the PECA regulation than other individuals. But it's a topic that Anna and I feel is beginning to have a lot more traction in the industry, and is absolutely beginning to gain more scrutiny from various different groups, which we'll come on to a little bit in the session. So what do we mean by cookies? So the legal bit and the legal definitions around this. So we're talking about pieces of software, and that could be a cookie, it could be a pixel, as it says, or it could be a browser fingerprinting, it could be SDK, and they're typically things that are used for things like email marketing, website design and hosting and so on. And the rules are environmentally agnostic. So it doesn't matter whether you're doing this on a website, whether it's an Internet of Things device, whether it's a smart device, etc. It's anything that can monitor and capture pieces of information about you. Now, why is this so connected to the GDPR? I mean, Anna and I have just said it's to do with PECA, so why is the two related? Well, the key thing is that for the use of these pieces of software, for these little pieces of technology like the cookies, we are typically needing consent. And the big change that occurred in 2018 is that we need to comply with the rules of consent as laid out by the GDPR. And we'll come on to those in a little bit more detail. Now, I've taken some of the slides here from an international solicitors company called Bird & Bird. I would encourage anybody with an interest in GDPR to follow Bird & Bird on LinkedIn. They are pushing out some fantastic content around data privacy and information security at the moment. Obviously, very much from a legal perspective, they are solicitors, but their slides that they talk without legalese. They don't talk as though you need a contract to understand what's going on. They are very, very clear in their communications. But for cookies, we need to ensure that we have consent unless our cookies are strictly necessary. And we'll come on to what we mean by strictly necessary a little bit later. So what do we mean by consent? So this is consent as it applies under the GDPR. It applies to any aspect of the GDPR, so not just the PECA regulation, but importantly, consent has to be freely given, specific, informed, and unambiguous. So what on earth does that mean? So freely given, it can't be conditional. You can't be saying things like, we consider you to consent to this. By using our website, we've considered that you consented. Well, that wasn't freely given, was it? It was conditional. It was conditional because you can only access the website by giving consent. So therefore, it's not freely given. It needs to be informed. You need to know what you're consenting to. If you don't know what you're consenting to, then how can it be informed? It's got to be unambiguous. You need to be really, really clear on what messages you're given across. And it then goes on to say it has to be by a clear affirmative action. So when we think back to marketing, for example, you have to click the consent box for marketing rather than the box being clicked for you. I mean, Anna, this is something that so many organisations tie themselves up in knots about, isn't it? I mean, what's your view on consent?
I think consent is one of those things, like you say, Helen, everyone, and even I get myself tied up in knots about it sometimes because it's so tricky. And, you know, I think the tip that I would give everybody is make sure that you are being honest with users about what you're doing and why, and giving them that information so that they can consent, you know, in an informed way. And that's all about, that's kind of tied into the GDPR as well in terms of what they call transparency. So the more transparency that you can give in that little consent box, or by a link to, you know, to something else, and then the more informed you are making the individuals, allowing them to make that informed consent. But yeah, it's very tricky. But as long as you're not making the decision for them, and you know, you're not pre-ticking those boxes, you know, that's a very good start when it comes to consent.
And the other thing about consent as well, which isn't documented here, but which is absolutely key, is that it has to be as easy to remove as it is to give. So if you have to go through hoops to understand what consent is in order to give it, then it's likely to be quite hard to remove that consent. So if you do something, and actually, I guess signing up to a newsletter is a good one, you need to be able to go back really quickly and say, actually, I've changed my mind. And the same type of application applies as well to cookies, absolutely the same. So if we just go back,
I think that's really important, Helen. So,
yeah.
Sorry, Helen.
No,
I was just going to pick up on the point that you mentioned there about being as easy to remove as it is to give. There's been some quite interesting information come out from the French regulator pretty much about that over the last week or so, and they've said that, you know, it should be as easy to reject cookies as it is to accept them. And while we've left the EU now, and the EU regulators are not necessarily have the same influence, I think it's still an important direction for us to just kind of be aware of.
Yeah, absolutely agree. So, and this again, this area of consent and strictly necessary cookies is where the UK is slightly deviating from where the rest, or from where some countries in Europe are deviating from, as I should say that. So what do we mean by strictly necessary cookies? You do not need to have consent for strictly necessary cookies. So what is a strictly necessary cookie? A strictly necessary cookie is one that helps your website to function. So for example, if on your website, if you have a contact us form, that form will typically be driven by a cookie, and you cannot then have your contact us form working if you haven't got the cookie. If you're a retail customer and you may have a shopping basket, then typically you've got a cookie that's going to capture the information which is around what you put into your shopping basket. That's strictly necessary for the functionality of your website. And the general rule of thumb for whether a cookie is strictly necessary or not necessary is it critical to the user's experience? And this is where analytics becomes really interesting, because the UK Commissioner has said numerous times that analytics on a website are not strictly necessary for the performance of the user experience. A user does not need to have their performance or their usage of a website tracked in order to exercise whatever it is they're trying to do on that website. That is the requirement of the company, and therefore consent is required. Complicated, isn't it? So how do we capture consent? Because this is also tricky, isn't it, as well, Anna? And I think the other thing is it's not consistent across Europe. But you've got to be really clear on your cookie banner. So, and we've got some really good examples which we share with you on good cookie banners, and we've got some examples of not so good. You cannot, where it says there, browser app consent, you just can't do it. So where it says, by continuing to use the site, you agree to the use of cookies as they are currently set. No, you cannot do that, because therefore you're not giving the user the opportunity to consent to the use. You are just saying that you're going to have cookies applied to your machine regardless of whether or not you agree to this. And you also shouldn't nudge them. So this is where you go to a cookie site and you can see banners which have got, I don't know, big text, as it says there, nice big green box where it says accept, and a tiny word with reject written in pale grey against a white background, which is harder to see. That's called nudging. So we can already see this is a complicated area. And Anna, I don't think it's going to get any simpler, do you, as we go forward? So we've decided we thought we'd give you some examples of sites that we think are not doing what they should be doing. So any comments, Anna, on the 3 examples we've got there of cookie banners that I've just found as I've been randomly browsing the websites of various companies?
I think this one's really interesting. These 3 are really interesting, actually, because from my perspective, there's a bit of browse wrap there going on, I think, where they're just saying, by using the website, you just continue and accept it. And I'm not sure if that top one, it's really tricky if we clicked on settings, whether it would actually give us the ability to switch them off. So I think that one's definitely a no. And again, that middle one there, we're talking about that kind of browse wrap again, which is if you're using the website, you continue to consent. Again, I'm afraid I'm giving it a thumbs down. Definitely a thumbs down.
Yeah.
And yeah, I think that one at the bottom there. I mean, we've got to find out more, but gosh, it's even I'm having to squint at the screen there, so I'm giving that one a thumbs down as well there, Helen.
and this is the other side of it, isn't it? You want the user experience to be easy to follow. So one of these, I can't remember which one of it is, it may be the bottom one, where it says find out more. It takes you through 3 or 4 different web pages to understand exactly what they're going to do with their cookies. And then the action is on you to then go and change your settings to prevent consent being switched to automatically on, which isn't in the spirit of the regulation.
I think another one I would give you all an example of, actually, as well, that wouldn't be acceptable is I've seen websites with banners that say you can alter your cookies if you're in this browser by doing this, or in this browser by doing that, and they give lots of technical information about how you can alter it at your end. But what they're not doing is altering it at their end, which is absolutely crucial. So, if you're seeing those websites that tell you that you need to do something in your browser, again, I'm giving that one a thumbs down, ladies and gentlemen.
I would agree. So it's only fair, isn't it, to show some examples of where we think there's cookie banners which are acceptable. So the one on the left there from the National Trust, I'm quite fine with, actually, as a DPO. Yeah, there's always some things that we could do to improve it, but that's telling me that what they're using cookies for. They're telling me where the cookies are being used. They're telling me what it's being used to do. They're also saying that some of them are essential and will always be turned on. But if we want to use others, then we can do that through managed cookies. Otherwise, just press accept all. And yeah, I guess you could say there's a bit of nudging there, but I think that's quite a good transparent policy. I think that's quite good and transparent. Conversely, the one on the right, you'd hope these guys get it right. This is the Information Commissioner's website. So again, what you've got there is the accept all cookies, the reject all cookies, and the ability to switch analytics cookies on, which is important. So the other key thing as well is that both these organisations are not applying cookies before you press accept. So that's really important, isn't it? Yeah. Right, consent.
And I would say that one from the ICO website there, Helen, is gold standard. You would expect it to be as well, given it's the ICO.
Yeah, absolutely. Now, just something else to pick up on as well. So this is slightly different as you go around Europe as well, which also doesn't help with the discussion. But consent, and for anybody that's been with us on GDPR sessions, they will know that consent is not forever. In the UK, the expectation is that consent is going to be no more than 2 years. But you can see already there's some different expectations there again around the lifespan of a cookie. you should always state on your website, if you are applying cookies, then how long those cookies are going to be on your website for. And there's a variety of tools out there that can help you do this. But just because somebody clicked on a cookie and said, yes, okay, back in, I don't know, 2017, you cannot expect that that consent will still be live and will still be valid here as we sit here in 2021. So that's really interesting. I can hear you going, yeah, okay, right, fine, I've got it. Cookies are a bit of a problem. So what's the problem? What's the problem? Where's the risk? We see this as a very much an emerging risk. And we've got two different examples here. So the first in the top left there, that refers to a case which is actually a little bit overdue for a ruling. So this is a case that was brought by a gentleman called, I think it's George Lloyd, and he brought it against Google. And the base of his case is quite an interesting one, and it works on the basis that Google bypassed some of the settings that were established in the Safari web browser used by Apple. And again, it applied cookie-like tracking onto websites that were used primarily by Apple users. And what that allowed Google to do was to take information that, in this instance, Mr. Lloyd was using, and to transfer that data to the US. Now, he is saying he did not know, he lost control. So that's one of the key tenets of this particular course, is that he lost control of his data. There was no transparency on that data being transferred by Google to the US. And therefore it has caused him a level of distress, and because he didn't have control of his data. Now, this is a really important case, because what it's actually saying as well is it's opening the doors to potential class action in this area as well. So this has the opportunity to go quite a long way. And that's one of the things that cookies can do, is they can transfer information. And again, it depends on the cookies, and not all organizations would be doing this, but they can transfer data to other organizations, which then allows for what's called real-time buying, where there is data that's brought together, combined and sold to bidders to allow them to advertise. So sometimes, if you've ever searched for a red jumper, perhaps you want to buy a red pullover on one device, and suddenly all you start seeing is adverts for red jumpers. That's typically going to be because of cookie technology that's been passed between various organizations, various marketing bodies, that then allows them to target marketing very specifically to you. The second example there is from an organization called NOYB, which stands for None of Your Business. If you Google noyb.eu, you will find that they are, I guess, how do you call them, a pressure group, wouldn't you?
Yeah.
So the leader of NOYB is a guy called Max Schrems. Mr. Schrems is very well known for his challenges of conventional thinking when it comes to data privacy. So anybody who's familiar with Safe Harbor and with Privacy Shield, he's the gentleman that successfully brought, I should add, those challenges against the applicability and usability of that regulation, or those agreements that transfer data between the EU and the US. What his organisation did earlier this year was it went out and it sent letters to just over 500 European companies that said, your cookie banners are wrong. And the reasons why he said their cookie banners were wrong are listed in that chart there. And this, again, is going back to the very points that we were talking about earlier, where consent was not correct, where there was no reject button, where non-essential cookies were being loaded, where consent was not easy to withdraw, etc., etc. Now, he sent those letters out at the end of May. He gave a number of organisations the opportunity to correct their banners. And if they didn't correct them, he was then going to send a letter making a formal complaint to the supervisory bodies in the country in which the companies resided. Last month, he then sent 422 letters of complaints to those supervisory bodies for failure by obviously 422 companies to react to his complaint. We also know as well that the French Supervisory Authority, an organisation called CNIL, so the ICO equivalent, but in France, is also finding organisations where they have not done the right thing when it comes to the use of cookie banners. And from a UK perspective, I believe, and this is a personal view, and I'm very open to any views and discussion on the topic, I believe there is a potential for future litigation by individuals who have lost control. So going back to the Lloyd versus Google case, who've lost control of their personal information as it's being transferred around the globe because of the use of cookie management. Anna, that's my view on this. It's quite a long spiel on my part. What's your thoughts and taking on this?
I think it's really, really interesting. I think my thinking is very aligned to yours, Helen, in that I think we're potentially going to see this area start to increase in attention, A, from the regulators, like you said, and B, from the individuals who use websites. People are becoming a lot smarter with this kind of stuff. And it's really interesting. NOYB are a fascinating organisation, and their campaigning, their ability to reach people and teach them about these kind of things, I think is certainly growing. I follow them quite closely, you know, and I think what's also interesting is that, you know, they've targeted, you know, this kind of group of 500 companies, but I don't believe that they're going to stop there. So I think it's one of those risks. I think it's one of those risks that I think we're just going to see emerging. And I think from the UK perspective, it was interesting to see the Information Commissioner, Liz Denham, actually putting out a statement about this in the last couple of weeks. And she was going to go and talk to, was it the G7,
Yes.
about how to tackle this in a group of countries rather than each individual country trying to do their own thing and seek their own pathway through this maze. So you know, there's clearly an interest from a UK, you know, from Elizabeth Denham's perspective to, you know, to kind of understand what the appetite is from the other regulators in the other countries.
I agree, because, you know, Anna and I as DPOs, we clearly, our role as DPOs is to uphold the rights of the individual, but we also understand the other side of this coin, that if you are a business, you've got a website, you need to understand whether your website's functioning or not. You need to understand, you know, where visitors are going, where are they finding the most use, whether or not their website's functioning incorrectly, is a visitor getting the best value experience from website, and you can only do that through analytics. And if you don't get individuals to consent, then you're losing that analytical data that allows you to improve. But currently, you need to have consent for that type of analytical cookie. I spoke with the Information Commissioner's Office last week in light of, as Anna said, the Commissioner's speech to the G7 nations, and actually a similar piece of case study or consultation that's come out from DCMS. The law is the law currently, you know, and we therefore have to abide by the law. And therefore, if you're putting analytics cookies on your websites, unfortunately, you do need to have consent. So it's a bit of a minefield, isn't it? So we've got a little bit of a checklist there, and I don't know whether you want to go through this for me. Kind of throw the consultant under the bus, but
I was going to say, no, thanks very much for that. Okay, so Helen, and thing is, I'm not going to get a cookie for this either. We're going to have no chocolate chip cookies given. No.
No.
Anyway, so maybe next time. Okay. So if you're not sure where to start, then here's a great checklist for you. So what you do need to make sure is that your users of your websites, of your applications, are consenting before any of those cookies are actually being applied to the device. And if this is something that you're going, how on earth do I do that? Then, you know, reach out to your IT teams, reach out to those people who manage your website. This should be kind of the bread and butter stuff for them, and they will be able to help you. You need to make sure that you're being really honest and open and transparent around the information that you provide about each cookie. So talk about the purpose in really simple language, and make sure that, you know, when they give that consent, they know what they're consenting to. And just to remind you, that is related to the transparency requirements under the GDPR. You need to make sure that you've got an ability somehow to document and store that consent that you've received from users. And, you know, that could come into play if a regulator may come and, you know, knock on the door and say, well, can you show me, you know, it's that typical thing that us auditors do and go, well, can you show me how that works? Can you show me how you do that? So be aware, you know, that you may need to be in a position where you show, you're able to show how and when that consent was received.
And
you then also,
sorry, no, I was going to say, and that sounds really complicated, but actually there's loads of web-based tools that allow you to do that, isn't there? So there's Cookiebot, there's OneTrust, there's all sorts of different cookie consent tools that allow you to do that when a user signs onto the website.
Yeah, absolutely. There are some really, really fabulous tools out there. Like Helen just mentioned, Cookiebot. You know, go and have a look at some of those tools because they make this stuff easy. That's what they do. And we all love to make sure that we've got the right people involved in what we're doing, and you know, have a look at those services. You know, some of them are free, some of them, you know, there are paid elements to it, but certainly have a look at it and see what you can find out there. Another tool, actually, Helen, are we going to talk about tools after?
We haven't included it here, but we can definitely put it into the chat box, can't we? Because there is a mechanism, isn't there, of working out what tools you've got and what cookies you've got, beg your pardon, and where the data actually goes.
Yeah, absolutely. I'll leave that to you then. So one of the other things you need to do is make sure that the individuals can still access your service on your website, even if they refuse certain cookies. You know, analytics and things like that should not be necessary for an individual to use your website. So make sure that they're still able to access the service, even if they don't give you that consent. And make sure it's easy for them to withdraw that consent. And again, that's where it comes down to the use of the right tools for that. And conduct a really simple data privacy impact assessment to document your thought processes in this space and document the risks and the solutions that you've put in place. And if you're not sure what one of those is, then you know, you can reach out to us. We'll be able to kind of give you some guidance on that. But equally, the ICO website are absolutely brilliant in terms of providing templates and things for all these things. Did I miss anything, Helen?
No, I don't think so. I don't think so. We were going to open it up to Q&A, but I'm just going to bring you back to one of the points that you said regarding the cookie analyzer tool that we use, the name of which has completely escaped me for the moment.
So there is a service out there called Page X-Ray, which allows you to, and we can share the link with you. It's quite a long link, so it's not something I can read out, but it's really, really fabulous. And what it allows you to do is analyze your own website or even other people's and understand what cookies are doing what. And there are also a number of free services out there that allow you to run reports, and you can download then lots of information about how cookies are being applied, whether they're persistent or, you know, just lasting for 6 months. There's some really useful information out there. So have a look around. And I think the other tool we've not spoken about, Helen, is Matomo. Absolutely.
I was going to come on to that, but carry on. Matomo, we love it, don't we? You carry on.
No, you go. No, you go with Matomo. I think it's useful for you to talk about Matomo because you apply it on the Risk Evolves website.
Yeah, so Risk Evolves uses a tool for our analytics called Matomo, M-A-T-A-M-O, pretty much as it sounds. It's actually used as well by the European Commission. It's recommended by the French CNIL organisations, the French equivalent of the ICO. It doesn't pass information outside of the EU, and it ensures that any data that you collect is owned by you as the organisation. And wherever possible, the data it collects is anonymous. And because of that, because it's anonymous, because it's held within the EU, because it's not being used by any other company, so it's not called a third-party cookie, it's used as a first-party cookie, you don't need consent. And that makes, for my life, running a website, it makes it a lot easier to not have to worry about consent for cookies, because I'm not using cookies that need consent. Regardless, sorry, I don't need cookies that need analytics consent. So we'd recommend Matomo to anybody. We've had it running now in the business for 6 months, something like that, and it does make life significantly easier than using some of the other third-party analytics tools that are available out there. And again, if anybody would like to talk about Matomo offline, very happy to do that, to show you some of the reports that you see, and also to share our web providers' experience as well, because they've been incredibly supportive in helping us get that up and running.
And I think it's important to say, Helen, isn't it? The analytics out of Matomo are actually really powerful, really powerful.
They're really, really good. Yeah, so I can still work out which countries people are coming from. I don't know their IP address. An IP address, just as a reminder, is a piece of personal information. I can work out how long they stayed on the website. I know which pages they went to. I can see their journey through the various pages, but I can't identify them as an individual. And that's the key thing from a cookies perspective. So that was a really short run through cookies, and I know Anna and I can talk about this topic for absolutely ages. If anybody has got any other questions on this, then please feel free to ask. It is going to be available, as we've said, on a playback session, which we'll load onto the website in a couple of days' time. But I think it just remains for me to say thank you for everybody for joining. Hopefully see you on the last call of the day, which is going to be at 4 o'clock again with Anna, and we're going to throw lots of random questions at Anna about GDPR and PECA and DPA and any other piece of legislation we can think about, which I know she's looking forward to already. If not, thank you very much for joining, and we hope to see you on the 9th of December. Thank you.
Thanks, everybody.